move on. Viewers, are we witnessing an all-out war between the executive and the judiciary? Well, I'm asking you this question today because the Vice President of India, Jagdeep Dhankhar, has sent out a very, very strong message to Indian judiciary. The Vice President has claimed that the judges these days are acting as a super parliament, whereas the reality is that the law does not even apply to them. He goes on to say that Article 142 of the Constitution has literally become a nuclear missile of sorts, as it is available to the judiciary 24/7. He even said that the courts cannot issue directions to the President of India. Remember, this specific comment from the Vice President comes just days after the Supreme Court heard a petition against the Tamil Nadu governor's decision to reserve 10 bills. Not only did the Supreme Court declare the governor's actions illegal and erroneous, it actually prescribed that the president of the country should decide within 3 months on such bills. And in case of any delay, the reasons will have to be recorded and conveyed to the state. Now, just days after this order, the Vice President said Supreme Court is not really in a position to direct the President. The Vice President further slammed the Supreme Court by saying that it chose to lean on the Constitution to use its powers to direct the Union's President. But the same Supreme Court adopted a path and procedure not laid down in the Constitution when it came to the alleged case of recovery of cash from a sitting High Court judge's official bungalow. He questioned, in as many words, the lack of an FIR in this case regarding the cash discovered from High Court Judge Justice Yashwant Verma's Delhi residence, saying that the independence of judiciary is not a cover against a probe. The last time the nation witnessed a judiciary versus legislature clash was over the NJAC bill in 2014, when the parliament passed it, only for it to be struck down by the Supreme Court as unconstitutional. Is this now possibly the most heated flare-up between the executive and the judiciary since then? Well, time will tell, but first listen in to what he said.
We cannot have a situation where you direct President of India, and on what basis? The only right you have under the Constitution is to interpret the Constitution under Article 145(3). Article 142 has become a nuclear missile against democratic forces. Available to judiciary 24/7 in New Delhi, at the residence of a judge for 7 days. No one knew about it. We have to ask questions to ourselves. Is the delay explainable? Condonable? Does it not raise certain fundamental questions?
And this comment by the Vice President hasn't gone down too well with the leaders from the opposition specifically. Opposition is saying that it's the Supreme Court's job to rein in anyone who crosses the limit. Listen in.
Judiciary cannot teach any lesson to the Parliament or to the President. But more than that, if anybody, whether it is Parliament or President of India, they cross their limits, then Supreme Court can issue a direction to them. That is the reason if we have passed any law in the Parliament or in assemblies and we feel that it is against the fundamental right of Constitution, it is against the basic rights of Constitution, then we knock the door of Supreme Court.
And we have a reaction coming in from Kapil Sibal as well on the statement made by Vice President Jagdeep Dhankhar. Kapil Sibal has hit out at the Vice President, saying that the Vice President has made political statements. He's called him biased. Let's listen in. Okay, we'll get you that reaction in just a bit. But meanwhile, let's go across to my colleague Rishabh for more on this. Rishabh, give us more details. What exactly has Mr. Kapil Sibal said?
Well, if we talk about Mr. Kapil Sibal, or we can say senior advocate Kapil Sibal, who also happens to be Rajya Sabha MP, has hit out at Rajya Sabha Chairman and Vice President Jagdeep Dhankhar, saying that, Jagdeep Dhankhar is on a constitutional post and he is making political statements and he should stop doing so. Also, hitting out at Vice President Kapil Sibal says that calling Article 142 of Indian Constitution as a missile is something that is unacceptable, and drawing a parallel from a judgment that came in from Supreme Court on Ram Mandir, Kapil Sibal says that when the judgment is in favor of government, whether it is against Parliament or not, the government is ready to welcome it. But now they are raising questions and allegations on judiciary that should stop. So Kapil Sibal very categorically saying that it's not Supreme Court but the Vice President who is crossing the line.
Right.
And remember, just yesterday,
Rishabh, stay on with us. In fact, we have that reaction ready for our viewers. Let's listen into what exactly Mr. Kapil Sibal has said.
तो मुझे इस बात का आश्चर्य है कि कभी तो बेगवाल जी जाकर कहते हैं कि हद में रहना चाहिए, कभी रिज्जू जी केरला में कहते हैं कि ये क्या हो रहा है, अगर हम भी करने लगे तो, और धनखड़ जी कहते हैं कि ये तो देखिए पुराने टाइम जब 8 जज थे सुप्रीम कोर्ट में तो 5 जज फैसला करते थे, मेजॉरिटी थी, अब तो इतने जज हैं 2 ही जज फैसला करें। भाई 2 ही जज फैसला करेंगे ना, सुप्रीम कोर्ट तो बेंचेस पे बैठेगा, या 3 जज या 2 जज या 5 जज या 7 जज या 9 जज या 11 जज, और एक बार 13 भी बैठे थे। तो सुप्रीम कोर्ट तो ऐसे ही फैसला करती है ना, 2 जज फैसला करें सारे देश को मानना पड़ता है, 3 करें सारे देश को मानना पड़ता है। सुप्रीम कोर्ट होती है। आपको याद है जब इंदिरा जी के इलेक्शन का फैसला आया और उनको अनसीट किया गया, तो सुप्रीम कोर्ट के मामला आया कि स्टे क्या देना चाहिए, किस जज का फैसला था? एक जज का, जस्टिस कृष्णा अय्यर, याद है आपको? तब धनखड़ जी सब ठीक था, क्योंकि अब 2 जज का फैसला है वो गलत है, क्योंकि सरकार के पक्ष में नहीं है। बट कृष्णा अय्यर का फैसला बिल्कुल ठीक था, वो तो एक जज थे। तो ये किस किस्म की बातें हो रही हैं पब्लिक डोमेन में?
So you heard what Mr. Kapil Sibal had to say. He said that it's a political statement that the Vice President has made. In fact, viewers, Times Now has also spoken exclusively to Justice Kurian Joseph, who is head of the Tamil Nadu panel on the state autonomy. While speaking to legal editor Harish Nair, he has backed Supreme Court in directing the President. He says there is nothing wrong in setting deadlines for the President. Listen in.
There's a lot of controversy over the Supreme Court in Tamil Nadu case recently, prescribing a time limit for President to decide on bills, and if withholding or rejecting give specific reasons. Is it judicial overreach? Because Constitution Article 201 doesn't say so, but if Supreme Court introduces it, it amounts to legislating, which is the domain of the Parliament. So this is one of the issues which will be confronting you.
No, see, there is another angle on which one should look into it. See, any constitutional functionary, because Constitution is supreme, if any constitutional functionary does not function in accordance with the Constitution, how that functionary should function is for the Supreme Court to say. So I don't find anything wrong in the Supreme Court having said that in reminding the constitutional functionaries that this is the way you have to function in accordance with the constitutional scheme of duties cast on you. It's not a power, it's a duty. So therefore, Supreme Court is right, according to me, in reminding the constitutional functionaries the way they should act on their duties cast on them under the Constitution.
But perhaps this is the first time Supreme Court is laying down some time limit for the President. So there is some controversy.
Yeah, precisely as I stated earlier, no, this is an organic document, Constitution. So whenever such challenges come, the Supreme Court gets an opportunity to look into those challenges or concerns, and then then issue appropriate guidelines or lay down the correct principles on which the constitutional functionaries should function in terms of the duties cast on them, or in terms of their jurisdiction, not their power. Sometimes people always misunderstand this power and jurisdiction. It's not their power, it's actually their jurisdiction, which is actually a duty.
Joining us on the broadcast this afternoon is Sanket Yeregi, who is a senior advocate in the Supreme Court. Good afternoon. Thank you very much for speaking with us here on Times Now. You know what the Vice President said yesterday has led to reactions from politicians, from people in the Indian judiciary. I want to ask you, where do you stand on this particular debate? We just heard Justice Kurian saying that Supreme Court is right in reminding the constitutional functionaries. But the question that the Vice President raised yesterday was that if there is something that's not right in the judiciary, then who's going to question them? And he referred to the Justice Verma case.
So there are two distinguishing factors in my opinion. Number one, the law-making authority or the power of the Parliament and the procedure to make law, which includes even the assent by the President of India. The Supreme Court has not intervened or not intervening in the powers of the Parliament insofar as law-making procedure is concerned, law-making authority is concerned. But the procedure to make law includes several steps like passing of the resolutions or the passing of the bill by both the houses of the Parliament, and ultimately it is sent to the President of India. But if the law is made but has not been implemented or not coming into force, even though the will of the people through the members of the Parliament has been approved or has been accepted by way of the passage of the bill, but has not been implemented because of non-signature or non-giving of the assent by the President, then there should be some reasonableness to impose certain conditions to act upon certain bills which have been passed by the Parliament. And in my personal opinion, the Supreme Court is only easing the procedure for making of the law, but it is not coming in the way of the Parliament's authority or the power to make law. So one should not misunderstand that the Parliament power is getting restricted or the Parliament's authority is getting restricted by the intervention of the Supreme Court. No,
right.
It is not so.
Okay,
but,
I get your point,
saying...
Mr. Sanket Yeregi, but you know the point that the Vice President was trying to make by taking these two examples was that, you know, on one hand, there is a deadline that the Supreme Court is setting for the President. That was the governor issue, the issue of the bills, etc. On the other hand, in the same breath, he spoke about the Justice Verma case. He said that you are setting a deadline for the constitutional authorities. But then what about something that goes wrong within judiciary? There has been no FIR so far. He said the probe speed is not even of cattle cart. Don't you think, like, is he wrong in seeking accountability from the judiciary too?
There are two distinguishing factors in my opinion. Insofar as non-registration of the FIR is concerned, that's a different issue which has to be taken in a different forum. But in my personal opinion, insofar as the President's power or the issuance of the direction to the President is concerned, if we understand the Constitution in a better manner, the President of India is the executive head of the country. Nothing more than that. And he is not elected by the members of or by the civilians or the citizens directly. So if that is the case, citizens directly elect their members of the Parliament who make the law. And that has to see the light of the day by implementation only when the President gives an assent.
Right.
If the President, for reasons X, Y, Z, not giving an assent or not returning the bill with a specific reasons, then there is no fulfillment of the wishes of the people at all.
Okay.
So in my opinion, there is a need to impose certain deadlines.
Right.
To the executive head, and that's what
agree
the Supreme Court
with the view of the Supreme Court. I'm completely out of time. Sanket Yeregi, appreciate you joining us here on Times Now and sharing with us your perspective. We have Atul Jain, who's an advocate, also joining us live right now. Good afternoon. Where do you stand? Do you think what the Vice President said is actually a wake-up call?
Good afternoon. As a student of law, or maybe as citizens of the country, we must understand that the limbs of the government, the judiciary, the legislature and executive, although this might sound very lame for somebody, but then the boundaries have been set for all the three organs. So the Vice President saying this, that the Supreme Court cannot act as a super parliament or, fire a nuclear missile at democratic institutions, we have to see it in the light of how the powers between the three organs of the government have been divided. We are not here to scrutinize the statement of the Supreme Court judges or of the Vice President.
Okay.
Let us try and understand as to how the three organs work.
Right.
I mean, there is a concept of judicial activism that is also going on these days.
Okay.
And different voices.
All right, Mr. Atul Jain, I'm out of time completely, but thank you very much for joining us here on Times Now and sharing with us your perspective. With this, we will slip into a very, very short break. We'll be back with lots more. Don't go anywhere.